Welcome to our Estate Focus. The topic is estate planning. My guest is Rod Ott. Rod is the estate planning attorney from Gordon, Mong, and Ott law firm. And Rod is here to share his expertise about family estate planning. Welcome.
Thank you, Colin.
Thank you for being here. So what is estate planning?
It's a fancy term that lawyers use to describe how to control assets while you're living and assets while you're deceased, but also control your physical well-being while you're living, not when you're deceased.
That's right. It's an interesting term. And so in terms of getting the estate planning in process, I mean, what is a health proxies and what is a durable power of attorney?
The healthcare proxy and the durable power of attorney helps you avoid going to court. And lawyers like to go to court for a very obvious reason, because of the fees.
Yeah, right.
Clients don't want to go to court because of the cost, but also because by having a healthcare proxy and a durable power of attorney, they get to tell people what to do, rather than having a judge tell you or your family what to do. Now, a healthcare proxy is a simple document. All it says basically is, I pick this person to act as my healthcare agent if I'm incompetent. And depending how it's written, it can in fact be limited or say you can do anything you want. All right. Generally, if you trust somebody to make medical decisions, I recommend giving them full control. Because without full control, you're going to end up back in court, and it's going to cost you more money. The difficulty I have, though, is people do not want to speak to their family and speak clearly about what they want to have happen in certain situations. Now, most of you out there probably think I'm talking about, well, I want to have a do not resuscitate.
Yeah.
I don't pull the plug. But the opposite is true. A healthcare proxy allows you to, in fact, put the plug in and pull it out. And a healthcare proxy avoids what is known as a guardianship. And a guardianship typically will take now somewhere around 6 weeks to maybe 3 months to get appointed as a guardian because of the time delays in court. A healthcare proxy avoids that completely. Now, durable power of attorney is the flip side. And really, it's what most people are more interested in. It's about the money. And a durable power of attorney says, I pick this person, okay, to act for me, to do whatever I say he or she can do. Now, again, between husbands and wives, spouses, generally the power is complete. You can do anything you want, etc. When it comes to dealing with children, sometimes you have to have a serious conversation about what you want that child to do or not do. For example, sell the house, not sell the house. Calvin has been involved continually. You have a durable power of attorney saying you have the authority to sell the house. I get involved and say, well, I don't know about that. And you have dialogue going back and forth. If the power of attorney is not written correctly, Calvin's going to have a hard time trying to sell real estate with that power of attorney. And you'll want to try to make sure that you say specifically what you want to have done in that document. Now, both of those documents will save you somewhere between $3,000 and $5,000 in general by avoiding going to court.
I see.
So those are the documents that help people while they're living. And most people think of estate planning as being what happens when you die.
That's not true. Yeah.
Calvin and I were talking, and my belief has always been that these two documents are the one thing that everybody should have and address so you can take care of yourself while you're living. Because no matter what your belief is, you're not here when you're dead. And so these documents are the most important ones to me as a practitioner.
Okay. So basically those documents would give the family members to act on your behalf.
Correct.
Yeah.
But it doesn't have to be a family member. If you don't have a family member, it allows you to select somebody who you trust, who knows what you want to have done, rather than to defer to a probate court judge who has no idea who you are.
Mm-hmm.
And then because you haven't said anything,
Mm-hmm.
has to guess at what you want to have done.
Mm-hmm.
And that, it's not fair to him or her.
Right.
And it's
right.
not fair to you either.
Yeah.
So
Right. Right.
either way,
Yep. Yep. That's right. It must be a known person. It's better. Yeah.
better.
Yeah. Right. And what are the last will and testaments and trusts? I mean, what are those?
I've always described the last will and testament as a letter that says the following, not to be funny, but to be funny. Hi, I'm dead. Because most people look at a last will and testament and says, it tells me what I'm supposed to do, but it doesn't tell you what you're supposed to do unless you're deceased. So that document has no power unless you are deceased. Now, a judge might use it to try and interpret what you want to have done relative to a healthcare proxy or durable power of attorney, but it still has to be interpreted. Once you're deceased, it tells the court what to do with your assets after you are deceased that are controlled by court. Now, one of your questions we talked about before coming in was, what is considered to be in your estate? And there are two estates. One is a probate estate, and the other is the complete estate. A probate estate only controls that property that you have in your individual name. For example, I own a piece of real estate. I own it with my spouse jointly. That's not in probate. If I am in fact own that property by myself, it goes through probate. So I have many situations where I have a last will and testament that controls nothing because everything is held jointly or it's held by a trust. Now, a trust is a contract that allows you to put assets into it that will bypass probate for purposes of the probate. But if you maintain your control of those assets, it's still considered to be a portion of your estate for estate tax purposes. So you can have a situation where you have no probate assets, but an estate tax, and you still have to pay the estate tax. In general, estate planners try to use the trust to avoid probate. But by avoiding probate, you avoid publicity about what's going to happen in your family. You see it all the time currently, okay? Kids have problems with drugs. You don't want to put a document out there that says, I will not give my son Johnny the money unless he tests clean.
Right.
But you may want to put that into a document to protect Johnny from himself. More importantly, there are situations with second marriages where basically you want to tell your first set of children, you don't get anything. And you want to tell them why, okay? Again, that should not be a public document. It should be a private document. The other thing a trust will do, besides avoid probate, is it can avoid estate tax if you set it up properly. And in Massachusetts, the estate tax goes into effect at $1 million. At the federal level, it goes in at $5 million. So for most of us, you don't have a federal estate tax problem anymore. For most of us, though, with a house in Massachusetts, take North Quincy right now, $400,000, three family.
Yeah.
Okay, you're very easily over $1 million without even trying between your insurance policy, 401k, and the house.
Right.
So if you don't plan as a couple properly, you can end up paying $50,000 to $100,000 in estate tax to Massachusetts that could be avoided by the use of a trust.
Right.
So most people come to me for a trust to try and avoid the estate tax. I like it better because it gives me a chance to tell my daughters, do it my way, or you don't get the money, okay? And most fathers and mothers out there, when I say that, would understand also that when you have more than one child, it also gives it a chance to say to the kids, if you fight, you're not going to get the money. So you carry out a situation where basically your children are prevented from fighting by what you do in the document, which I think is important.
Right. Yeah.
Now, before I forget, if some of you have trust out there and you think it's going to protect you from your creditors, understand that it does not protect you from one major creditor, and that's the state and the federal government, actually two. One of the things we do in estate planning now is try and address the problem of long-term care, also known as nursing homes. A trust can be used to do that, but the problem is it has to be the proper type of trust. If you maintain control over that trust, that property is still subject to long-term care. Now, for many people out there, they come in to see me concerned about estate taxes, when the real concern should be for a married couple, the concern that makes sure that the surviving spouse, the non-custodial spouse, can in fact live comfortably, even if the spouse is in a nursing home. You know what the rules are? No.
Nope.
Okay. I'm sorry, I set them up, okay? For Mass Health, a couple gets to keep the house plus $110,000. Everything else has to be spent on long-term care. So if you have that house in North Quincy, okay, you can keep that house, okay, basically, unless it's worth more than $750 rounded, plus roughly $120,000. My question has always been, how do you stay in that house when they take all that money, all the rest of your money, for long-term care? It just doesn't work out. A lot of what I do with my partner Terry Amond right now is, in fact, sit down with families and try and discuss the ramifications of long-term care and how to plan through trusts and gifting to avoid losing all those assets to Massachusetts. And whether you agree with it or not, I agree that you should make a decision as to whether or not you want to pay that or trying to avoid it like everybody else. And I have clients actually have told me they think they want to pay it.
You want to pay it?
Yes, because I think it's
the right thing to do.
the right thing to do. And as a lawyer, it may be the right thing to do, but nobody else is doing it. So I have a hard time grasping that, okay?
They want to be different, I guess.
Correct.
Yeah, thank you so much.
Okay.
Yeah, and in terms of probate process, I mean, how long will it take to get the court approved? About a month, or
it depends.
Yeah, it depends, right?
Okay. They've changed the rules relative to probate roughly 2 years ago. They now have a thing called an informal probate, where basically you can go down and file the documents, and if everybody agrees, you can get appointed probably within 4 weeks to 8 weeks without a problem. If somebody does not agree, it's going to take you somewhere between probably 2 months to 4 months to get appointed. But the problem is that appointment is not the only problem. Anything in probate is subject to creditors for 12 months. So technically, you can't give out the assets to your heirs, the children, etc., for a 12-month period because all those assets are subject to the claims of creditors. So that's another reason why we try and use the trust, because having a trust set up appropriately, you can in fact avoid some of the risk of the creditors, particularly for the surviving spouse, not the person who died. So it's another reason to use a trust.
Right. And this is usually people ask, and then try to be curious as well. What does a probate judge and what does a probate judge do? So it could be a long and short question.
A probate court judge is an individual appointed to be a judge. And what a judge does in general is decide cases based upon what is presented before them for the people before them. Now in probate, you'd be going in before a probate court judge for one of three different things basically: a guardianship, a conservatorship, or a probate estate. In a guardianship, if you don't have a healthcare proxy, the judge's job is to try and determine what you would have wanted to have done for you, okay, in the absence of any clear expression in a healthcare proxy of what would occur. There have been many famous cases about people arguing about taking people off life machines or putting them on. I'm trying to remember the woman's name, I just went blank. It was in Florida. There was a big fight that went on for almost 8, 9, 10 years. And finally, when she did pass, okay, it was after she had been taken off and she'd lived for a period of time. But that judge could not make a decision because she had never said what she wanted to have done. Have a healthcare proxy. Okay. I also have a thing I call a personal wish list. And it's actually an oxymoron because what it says to the family is, this is what I don't want to have happen health-wise. You can go through, and it forces my clients to talk to their kids particularly about what they want or don't want to have happen to them, okay? And actually have the discussion with the children about who has the ability to make the decision. Now note, if you don't have the healthcare proxy, the judge is making that decision.
Right.
Now, in a durable power of attorney situation versus a conservatorship is appointing somebody by the court who the judge picks to manage the person's financial estate. That includes rental property, the house, 401k, IRA, etc. And it also can include setting up a estate plan through the approval of the court. But once again, the difficulty is you have to get court approval for things as go along. For example, a conservator typically would get a court approval for the sale of a piece of property called through the license to sell process.
Right.
And that's going to be, we're in Norfolk, so it's a pretty good county, okay? So I'd say 5 to 10 hours to get it done, okay? That's still going to be, on the average lawyer's $3,000. You're spending that a durable power of attorney would have avoided. Now, I actually think a judge has an easier time being a person deciding about a conservatorship, durable power of attorney, because finances are pretty straightforward. The guardianship for the healthcare proxy, I think it's actually more of an emotional, more difficult situation. The third thing they do in my area of practice is handle probate disputes. An example would be, I just have a case right now where 6 daughters are fighting over a trust accounting, and basically it's been delayed for about 5 years where they fought back and forth. And there's been some delay caused by the kids and some delays caused by the court, and it finally got resolved back in March, but the money should have been paid out 5 years ago. But just the way it happened, the fight started.
Right.
And that's kind of a long time. Usually a fight like that would take about 2 years to 3 years. And the judge makes the decision based upon what's in front of him or her about what will happen to that estate. And the irony to me has always been, Calvin, that you can have what I think is a very clear document that I can read, but when you read it, it doesn't look so clear anymore.
Because you're an expert, right?
Okay.
Yeah, that's right.
But at the same time,
Yeah.
that's what the judge is doing.
Right.
By the way, the other thing that probate court judge does, you get divorced, you don't want to see them because they tell you what to do, and whatever they tell you to do in divorce, you don't like. So,
Yeah, that's one of the worst emotions to have, and basically so. And in terms of people who have wealth, and how soon is too soon to have something like this in place? Estate planning, or
it's actually
durable power of attorney in their 50s or 60s, or
No.
are they healthy?
Well, the health is the best way.
Yeah,
but
that's right. Yeah.
it's interesting when you ask me a question like that, because you're looking at people probably more my age
Yeah.
or your age, but in reality is the first time you need to have an estate plan for sure is when you have a child.
Right. Oh, okay.
Because when you have a child, basically all of a sudden you have to start deciding who's going to take care of the child if you both are gone. And more importantly, if one of you are gone, how are you going to set up the money for that child that is generally generated by an insurance policy for the child after you're gone? Now, a lot of the clients want to give the spouse full control over the money. But strange things happen when you die. Your spouse gets remarried. And at that point in time, you have to worry about whether or not that money is going to be used for your child, or it's going to be used to take care of your spouse and the new spouse and their kids. And by having a trust in this situation, you can make sure the money is used for your child,
Right.
and also for your spouse. But you give some ability to them to not, in fact, have to have a prenuptial and take that money off the table.
I see. Yeah.
That's the first time.
Yeah.
Second time, fast forward to when your kids start to be going to college, and at that point in time, you should have an estate plan to address what happens if you die and one child has finished college and the other child hasn't finished college. If you die in that situation and you don't have any documentation, the money is split between the two kids. And I've always thought that it's not fair to the child who hasn't gone to college versus the child who has. More importantly, at that point in time, you have to start considering what's going to happen if you give the money to your kids. Now, over 30 years of doing this, I used to think that when a child went out and just blew the money on a good time, be it a car, a trip, etc., how horrible it was. As I've gotten older and the hair's fallen out and the beard's gotten gray, that's a bad thing, Calvin, because at least they're having a good time. In the last 2 days, folks, I think Apple has lost 30% in the market. One of my clients, okay, has in fact a major position in Apple, and many of the kids that I have dealt with think they should invest in just one stock. If it's a stock, it's a pretty good deal, folks. If it's a restaurant or a boat, just throw the money in the hole and let it go, okay? So again, when you have the kids, that's one of your responsibilities.
Right.
Now, get to my age, okay? At my age, I'm still trying to take care of the kids, but if I were to die, the other thing I'd be doing with my estate plan, and why you need it, is I can take the money off the table so I can take care of my spouse after I am deceased. But Medicaid and estate taxes will never get it. So your spouse has the ability to use the money to live comfortably and do what he or she wants, but the government can't come in and take it for taxes when she dies or he dies, and they can't take it for long-term care. So, the answer to you is, an 18-year-old or younger doesn't need an estate plan. 18 to 30 without kids, I don't know. Between that age group, once you start having assets, though, you should start thinking about who you want to get them. And most kids, 18 to 25, don't have much money.
Right.
Look at the Red Sox, though.
Especially now.
Well, especially now,
Yeah.
But the Red Sox or the Patriots, etc.,
Yeah.
they should be.
That's right.
So
Right.
money is one reason, but I think personal reasons are more importantly.
Right.
Last but not least, if your spouse or your family member has a medical condition, be it CP, etc., you need to have an estate plan to make sure that they get the money, it's not taken away from them. Okay.
Right.
So when you ask me that question, always makes me kind of smile, because everybody should have an estate plan. Okay. How complicated it is up to you.
Yeah.
But the real question is not to have the estate plan. The question is to make sure that you, in fact, think about what you want to have and not have and decide to do it. Now, I had one 80-year-old gentleman who said to me, I'm not going to have an estate plan. My kids have been a pain in the tush. Let them, God bless him, okay. Let him fight. But he thought the process through.
Right.
He wasn't going to pay me X amount of dollars to make it easier for them. Okay, and in fact, he deliberately had a durable power of attorney and a health care proxy. He did not have the kids' control. That was his decision. Now note, I can't tell you the name, okay? But, okay.
You don't have to.
Okay, all right.
Yeah.
So,
So it's never too soon. It's never too late. So, but the sooner the better. That's what it is. It's a long-term thinking.
It's a long-term thinking, but for long-term care, folks, there is too late. You cannot, in fact, do long-term care planning just before you go into a nursing home. You have to do it at least 5 years beforehand, or if you have advanced age, and pick advanced age for yourself, okay? All right. You have to do an estate plan, I think, that tries to address whether or not you want to try to avoid that or not.
Right.
So,
that's good tips. Yeah.
Okay.
Good tips. And the last question is that how do most consumers look for estate planning attorneys? Referrals is one of them, right?
I was going to say, I get most of my business right now from referrals.
Yeah.
Okay.
Right.
People who have done work for before.
People trust you.
Okay, and they say, why don't I get my referrals because of the way I talk right now, folks. That basically, I don't think worrying about estate taxes necessarily is the major thing to do, or avoiding probate. The major thing to do is try to decide what you want to do for your family and or yourself through the documentation. So my discussion a lot of time to begin with is, what do you want to do?
Mm-hmm.
Okay.
Yeah, right.
Do you care what happens with the kids? Do you care what happens to your spouse?
Right.
Do you want to reduce estate taxes? And the most difficult thing to talk about is the healthcare proxy. And if your child has a problem, that's hard to deal with too. And those are the two things I push on.
Right. Yeah.
Okay.
So great. And who will get the most money, right?
Well,
At least family members.
I was going to say
or-
among family members, that's correct. Okay.
That's right.
Okay.
Well, I want to thank you so much for sharing. Yeah, thank you. And
So, geez, that went fast, folks.
it went fast. Yeah. Time flies by while you have fun. So yeah,
Okay.
yeah. Thank you for being part of the show. See you next time.